Hey guys, and welcome to today's video. Today, I have two videos to cover, with the first one being of a human colostomy bag who did some deplorable things to someone who's not old enough to vote yet, if you know what I mean. Thankfully, he's in Judge O'Donnell's courtroom, and Judge O'Donnell knows exactly how to handle people like this. And then I have a video of a doctor who borrowed money from one of his business partners to cover business expenses, but instead decided to use it on other things. We have a word for that. It's called fraud. Both of these cases have extremely satisfying endings. So let's begin.
First and foremost, I'd like to apologize to the courts for appearing before them today. I'd like to apologize to the victim in this case. I'm not going to use alcohol or drugs as an excuse for anything. However, alcohol was a main factor in this case. But I take full responsibility for my actions because I chose to make the irresponsible decision consuming too much alcohol than I could handle, causing poor, regretful choices leading to my incarceration. I've read the police reports and feel ashamed, embarrassed, and hurt because that's not the person I am. And I wouldn't be standing here today if I would have just been more responsible. I have 4 younger children that I've let down because of being locked away from them, missing out on watching them grow, having to deal with that as a heartache alone. The only thing I can do now is work on myself while incarcerated, take advantage of all programs they offer, and become a better man and a better father, and not give up doing so. I have to make this my last time in jail, and I plan to. I'm sincerely remorseful to my victim in this case, letting her down when I was supposed to be a father figure in her life. I beat myself up over this every day. Over this, wishing I could take it all back. I just hope she can grow up in life and leave this in the past, and that it doesn't affect her future. Again, I'm sorry to everyone I caused pain to in this case.
Come on now, don't beat yourself up too much. Make sure you leave enough for the people who are going to be beating you up every day of your life for the next decade. And part of taking responsibility is not spending the first half of your apology blaming alcohol for your decisions. Now, after this, the prosecutor laid out exactly why he deserves his sentence, which I'm not going to play due to the sensitive nature of the case. But a few things to note. He committed this criminal act against a stepchild in front of his own children. He placed the blame on the victim and told the victim to beg for a light sentence. And during his pretrial sentencing interview, he said he did nothing wrong to begin with and that he wants to take this to trial. And finally, the prosecutor asked for the recommended sentence to be imposed of 8 years in prison. Now all they have to do is convince Judge O'Donnell to buy his bullshit story and go along with the recommendation.
Thank you. Why did you call her after you were in jail?
Because I was told by the detective I was allowed to.
Okay.
I didn't call her, I called my wife and she answered the phone.
All right. And what contact did you have with her about retracting her statement or modifying her
It
statement?
wasn't retracting. We talked about counseling, going to counseling and stuff, because that was something that they was talking about making them do, and something she said she didn't want to do.
Well, trying to whether directly contacting her or contacting her through your wife was wholly inappropriate. And it was further evidence of you trying to take advantage of her at that young age, like you did when this happened.
Now she had asked the detective if she could have contact with me when this case was all started. Then when I went to my preliminary hearing on February 11th, I asked the detective and he told me the same thing.
All right. Well, you're experienced enough in the system to have the wisdom that you shouldn't have been contacting her. Okay. In talking to her, having about anything having to do with this case. So, you've in your statement you say you apologize to her, but then in the pre-sentence report you talk about how you don't believe you did everything you're accused of doing and wanted to take this to trial. What's that all about?
I don't remember exactly what I said, Your Honor, but what I was saying was I don't have recollection of what happened the night of. So I wasn't admitting to, I don't know what happened.
You You are ready to take responsibility for your actions because you know exactly what happened, whether you can believe it or not. And the following clip displays exactly why I love watching Judge O'Donnell.
So did you or didn't you do this stuff?
Yes.
And I got to tell you, it doesn't get much worse than this kind of stuff.
I understand.
And I would note in the record that in 2009 or 2010, you were sentenced to prison on a burglary, released on judicial release, and then returned to prison after a violation of the judicial release. And you were released January 7th of 13. You went back to prison on another case on May 1st of 13 and got out in August. Went to prison on an attempted burglary, trespass and a habitation, breaking and entering June 23 of 16 through August 5 of 18. A whole bunch of theft offenses between that last prison sentence and where you are today. So you've had a lifetime of criminal activity, but none worse than what has occurred here. So I've reviewed the pre-sentence report and a victim impact statement. I've considered what you have said, what counsel has said. And I've also considered that they've made a joint recommendation of 96 months in prison. And so on count, and I've considered all the provisions in 29, 29, 11, 29, 29, 12, 13, and 14. In consideration of all that, on count 5, I'm going to sentence you to a term of 60 months. On count 6, I'm going to sentence you to a term of 60 months that will be consecutive to one another with credit for 143 days. And consecutive sentences are necessary to protect the public from future crime by you and for appropriate punishment.
All right, get out, man. Come on, man.
Sit
What
down.
you mean, man?
Stay down.
No, man. Get me the
Yeah.
fuck out of here, man.
Judge.
Come on.
And-
Fuck, took my plea back, man. Get me the fuck out of here, man. Get me out of here. Get me out of here, man.
Sit down.
Get me out of here, man.
Almost done, Judge.
Get me the fuck out of here.
And they
No, man. Get me out of here. Get
consecutive.
me out of here, man. What the fuck you mean, nigga? Get me the fuck out of here. Man, get me the fuck out of here, man.
Let me get my leg.
Get me out of here, man.
Just take him into the chair.
Okay, we're in the chair.
All right.
We're kissing tomorrow.
Put me on your visiting list
Alright.
for jail and
All
prison.
right, man. Stop touching me, man. I'm not doing shit, man. I'm not doing shit. I'm not doing shit.
Bye, have a great time.
All right, well, it looks like he won't be hurting anybody under the voting age anytime soon. And if you ask me, well, I don't think 10 years is enough time. With his crime and his attitude, he'll be lucky if he makes those 10 years without having to have some kind of medical equipment permanently attached to his body. All right, so now we're on to our next hearing, which involves a dirtbag doctor who borrowed $12,000 from a business partner to cover his own business expenses, then used it on personal items and never paid the loan back.
Let's see. How about Mr. Hetherington? Looks like you're back there. Actually, I've got maybe another file. Pamela Ronaldo Dicus versus Kirk Gold.
That's correct, Judge.
Do I have Kirk Gold?
Yes,
Anybody?
Your Honor. Kirk Gold is here.
Okay, on that phone it looks like. Mr. Hetherington, looks like I scheduled this for evidentiary hearing for, I guess, oh, the amounts, it looks like.
Correct, Judge.
Mr. Hetherington, I guess have the parties talked at all before we proceed?
Yes, for about 2 years, Judge.
Oh, okay. We're kind of at the end of that. Okay. Uh, Mr. Gold, are you ready to proceed?
I'm waiting for my attorney to call me back. I put a call into him because Mr. Hetherington proposed a resolution, and I just need to run it by my attorney to make sure it's the right thing for me to do at this point in time. And it was unfortunate the witching hour yesterday, and I understand and respect this court's time, but I didn't get a response. I expect I'll get a response this morning when the attorney gets into the office.
Mr. Hetherington, I guess I'll leave it up to you if it's easier just to see if it,
Your Honor, the issue in this case is this has been ongoing for 2 years. We were here 2 weeks ago. He did not bother to call me until Friday morning. I was out of the office. I returned his call yesterday. We did not have an opportunity to fully discuss the matter until yesterday afternoon. He's had a couple weeks to talk to a lawyer to see what the best outcome would be. We are prepared to move forward.
Your Honor, sir, sorry for the interruption. Mr. Hetherington, I did call you the day after our trial. We did speak on the phone, and I told you that I was going to be working on it and seeking legal counsel. And then, yes, I did try to call you on Friday before the weekend, and you were not available.
now, it is time set for a motion. Who's your attorney?
My attorney is Maury Lefkowitz.
The only thing I guess Mr. Hetherington, I'd allow him to do if he wants to make a quick call, I'll let him do that. If it was the proposed, I guess the proposed offer is something you'd consider if he gets a response from him right now.
Yes, Your Honor.
Okay. So if you want to try to call him right now and tell him that you're right in your hearing and the judge is giving you a chance to talk to him real quick. You want to do that?
Yeah, I'm not sure how I would do that with me being on the phone, how it would.
Well, you can, I'll tell you what, I'll let you hang up. I'm sorry, I just took your number off there. What's your phone number so I get it when you come back on? What's your phone number again?
248 20.
0.
Right.
Okay, I'll look for you. If you want to hang up and try to call him real quick, I'll let you do that, but you got to come right back on, okay? Otherwise, we'll end up proceeding just without you, and I don't want to do that either, okay?
Okay, let me try to call him.
Okay, all right.
Okay, thank you.
Sure.
All right. Yep.
Sure.
Okay, so he said he's consulted a lawyer, and he did throw a name out there, but I don't think he actually called a lawyer to begin with, and that he just called him when the court gave him a break. Because listen to the excuse he gives for the lawyer not being there when he's supposed to.
Pamela Ronaldo Dicus versus Kirk Gold.
Ready, Your Honor.
Okay. Come back here. Do we, oh, there he is.
248 number, Judge.
Yeah, thank you. I just found him. Yeah, he's coming back in.
Hello.
Hi, Mr. Gold. You back?
Yes, sir.
All right.
Yeah, well, I was actually calling Mr. Rick because I hadn't heard from you for 20 minutes. My attorney's in consultation right now, but he's going to try and call me at 11 when he's finished with his first consultation.
Mr. Hetherington, I'm going to leave it up to you.
I'm trying to get this resolved. I really am.
Your Honor, it's been, like I said, it's been 2 years, and it's been 2 weeks since we were here last, and he didn't call an attorney till last night. We're ready to proceed.
All right. I think at this point we need to proceed then.
Can I have one more chance to at least talk to my attorney and just get an answer for you, Mr. Rick? Can I at least do that out of good faith? I know you're trying to get this thing done, and I can appreciate that. But that's just a huge amount. It's a huge amount. If I can get this done and do what we talked about yesterday, then everybody wins.
Well, I thought that's what we were doing right now. I mean,
Well, we are. I just have to run it by my attorney first and make sure that that's the right thing for me to do. I mean, that's what counsel's for.
well, it is, but you're putting your counsel in a bad spot too. He or she should have been called much earlier too. That's the problem.
We had talked, but just we have not connected since.
Mr. Hetherington, I guess if you want to just proceed, we can do it. Or the practical side, if it's a reasonable offer and it looks like it's going to be done.
Your Honor, again, we're ready to proceed. There's been too much delay in this case as it is.
Okay. All right, let's just proceed with this time then. It is
Please.
just set for evidential hearing with regard to the conversions fraud. Do you have a witness, Mr. Hetherington?
Your Honor, I'll just call Mr. Gold.
Oh, okay. Mr. Gold, can you get on video for me?
I'm in the car driving right now, sir.
Well, you can't be driving anyways. You got to pull over for me. Are you pulled over?
I'm pulling over as we speak.
Okay.
Now, how do I do this? I'm on the phone right now.
Okay, you just gotta, there's a button that, well, probably at the bottom, it looks like it says video, or it's got a little camera, it looks like. It's got a,
I just have a call screen. That's all I have on here.
Your Honor, I think he's actually on the telephone, not on the Zoom.
oh, you know what, we can
They're called
proceed. Mr. Gold, why don't you raise your right hand for me? You're pulled over though, right?
Yes, sir.
Okay, why don't you raise your right hand for me? You
So,
got your hand?
this
Hold on, you
this
got
is a
your hand
done deal,
raised?
then, right?
Well, I haven't heard
Yeah.
anything yet.
Yes, sir.
Okay, you got your hand raised?
Yes, sir.
Do you swear from the testimony you're about to give will be the truth?
Yes.
Okay. Mr. Hetherington?
Thank you, Judge. Mr. Gold, where are you employed?
I'm in private practice.
What kind of private practice?
Podiatry practice.
So your title is a doctor, is that correct?
Yes, sir.
And back in 2023, is it true that you entered into an agreement with the plaintiff in this case to borrow the sum of $12,000?
Yes, it is.
And did she in fact give you the $12,000?
Yes, sir. She did.
And was the agreement that you would repay that amount within 6 months?
I don't remember the specifics exactly, so I can't attest to that under oath.
Do you recall making any payments on that loan?
Yes, I did make one payment or two
Was that
payments.
for-
I'm not sure. I made
And was that for $1,000?
yes, sir.
And so you would agree that you still owe $11,000 on that loan, correct?
Yes, sir.
And that occurred, that loan actually occurred back in May of 2023. Is that true?
Yes. I think it was
And-
May. I'm not sure exactly what the date was.
Okay. And then you used that money for some interest personal to yourself. Is that correct?
Correct.
And since that loan and since that initial payment, you've had discussions with the plaintiff in this case
Yes.
about repaying that loan?
Yes.
And you've not made any additional payments. Is that correct?
That is correct.
And then in
I just-
January of this year, did you receive demand letters from me?
I received a letter, I believe it was in the early part of February.
Okay. And then we had some discussions, correct?
Yes.
And I provided you with opportunities to try to solve this matter. Is that correct?
Yes, you did. And as I stated to you then, and I'm saying to you now, it was a cash flow with insurance issue. and I was trying to rectify that, and I see it starting to become rectified, but it looks like the cart is in front of the horse a little too far. I'm trying to catch up to it. I can't quite reach it, but it looks like I can reach it now, but it looks like I'm out of time.
Well, you were actually out of time 18 months ago when you promised to have the loan paid off. And I heard you mention that it was an insurance cash flow problem, which you would have thought if you took out a loan and used it as you said you would, the cash would have started flowing again by now. Maybe the insurance companies thought the claims you filed were about as honest as you were being when you took out this loan.
When you made the promise to repay that loan within 6 months, did you believe that that could happen? Or were you unsure if that could happen?
I believed it would happen, yes. I'm not sure that it was 6 month thing that I said, but it could have been. I think paying. Yes, I can't recall, so I'm not gonna say something that may or may not be true.
Well, when you made the
But yes,
representation,
my intention was
when you made the representations,
my intention was to pay her as a friend.
understood, but when you made the representations, you weren't sure whether or not you'd be able to make the payments, correct?
I was pretty sure. Yes, I was. I thought I was pretty sure, but things changed.
I have no further questions, Judge.
Mr. Gold, was there anything in writing between the two of you?
I just maybe her and I made like a 1-page document saying that I would borrow the money and I would pay her back in installments.
Was it, and I don't, you to bear with me, I don't have anything in front of you. Was it a handwritten letter or some sort, or
Yeah.
what was it?
It was handwritten between the two of us. She wrote it, I signed it. I'm not sure. I don't remember what the specifics were of the letter itself.
Again,
Verbatim.
I don't want you to just guess either, but was there a payment structure that it would be paid in full by any particular time period then?
No, nothing with an end date on it. I just said that I would pay her like $1,000 a month until it was repaid, and then I got hit with some bad things, but that's not the court's problem. That's my problem. So that's why I was unable to pay. But my intention still is to pay my friend back. That's still my intention. I just haven't done it.
What was the loan for originally?
I was having monetary issues with deductible season.
I'm sorry, what does that mean?
Insurance companies. I mean,
Okay.
insurance companies that when you see patients, the insurance companies hold on to deductibles and charge the patient. So I have to hold my claims before I submit them. So I did not have any cash flow coming in at the time, and that's what I was needing the money for to survive.
Okay. Was that part of the understanding with the loan that this was strictly for your, I guess, your business? Or was it just a loan? I'm sorry, yes, it was for the business.
I'm not sure exactly what your question is. Could you
Was
maybe
it,
say that one more time?
yeah, was the loan for, was it just an outright loan here? I'm gonna give you this money. You use it for whatever you're gonna use it for, or was it more specific that, listen, this is a loan for your business?
No, it was the first example that you used.
Just a general loan of some sort?
Yes. Yes, sir.
Would you like us to believe that glue tastes good as well? Because I'm not buying your story that this very specific business loan was actually to be split between business expenses and living expenses, and that was your deal with the plaintiff, especially since you can't even remember the terms or whether or not you made one payment of $1,000 or two for $500.
But you were gonna be paying though $1,000 per month starting, I guess, when was that supposed to start?
I believe the month after the loan was initiated to me.
You did make, it sounds like one payment of, was it a total, one lump sum payment of $1,000 at some point?
I do not recall if it was one of 1,000 or two of 500. I don't remember exactly.
How did you make that payment?
By check.
A check, some sort?
Yes.
Was there a discussion as far as being late on that payment with the two of you?
On that payment, no, that was on time. That wasn't late.
Okay.
And then we had
What-
discussion as time went on. And I said to her that my intentions were I still wanted to pay her, but I just was having cash flow issues and cash crunch issues, etc.
Okay. And what did she say when you asked her about that? Saying that you had
She
cash
seemed to be
flow
okay with
issues.
that. She seemed to be okay with that as long as I was going to continue to pay her. And unfortunately, I didn't make the effort. I didn't show the effort that I wanted to, that I should have.
Okay.
I'm looking back, it was the wrong thing to do. But as I told Mr. Hetherington yesterday, I want to rectify it, even if I got to start with this and do this, and this.
Okay.
And he brought it to his plaintiff.
The money that the 12,000 that the loan was given for, part of the allegation is that it was disposed of without her consent. Meaning that apparently
I'm not sure.
they're saying that there was some type of an agreement that you could only use this money for a specific thing. Is that true or not true?
I don't recall that to be true at all. I don't recall that at all.
Okay.
I do not recall that.
Well, that's a lie, and I don't want to give away the ending, but the plaintiff's about to testify, and she's not stupid. She's a doctor too, and she remembers the loan and its terms with specificity. I guess now is the time for her to tell her side of the story.
Mr. Hetherington, anything else with regard to my questions?
Nothing for Dr. Gould.
Okay. Okay.
I'd briefly call my client if I may.
Okay, sure. Ma'am, why don't you raise your right hand for me? Do you swear from the testimony you're about to give will be the truth?
Yes, Your Honor.
Okay. Mr. Hetherington, you can proceed.
Thank you. Ms. Ronaldo Dicus, did you enter into an agreement with Dr. Gould to loan him some money?
Yes.
How much did you loan him?
2 checks of $6,000.
So that's a total of 12,000.
Correct.
And when do you recall that loan agreement being made?
On the date that you gave a short time ago.
So that would have been May of 2023.
That's correct.
And what were the terms of that agreement, if you recall?
Dr. Gold and I were in clinic seeing patients. He said he needed to borrow the $12,000 because he could not meet his payroll obligation that week. He gave him 2 checks of $6,000, each indicating they were to be paid in sums of $2,000 in 3 sums of $2,000, each check representing 3 months for a total of 6 months. He paid one payment of $1,000 upon my demand of legal action against him. No further payments have been received.
And you have had conversations with Dr. Gould since that time, correct?
Numerous conversations verbally and by text.
And he has not made any additional payments whatsoever.
That's correct.
And at some point prior to engaging my firm, you had another lawyer send him a demand letter, is that correct?
Yes, attorney Tony Mainprice prior to him moving to California, I'm sorry.
And was there any response to that demand?
There was no response.
And then you employed our firm and we sent a letter, correct?
Correct.
And you and I had discussions about the fact that Dr. Gould had contacted me after my letter, is that correct?
That's correct.
And at some point we were at least hopeful or quasi hopeful that there could be a resolution.
That's correct.
And to date, we have not reached a resolution, is that correct?
That's correct.
And to your knowledge, Dr. Gold has used that money for some personal interest. Is that true?
I was told it was used to pay payroll, that upcoming payroll.
No further questions, Your Honor.
Okay, Mr. Gold, you get a chance to ask her questions as well for me. Do you have any questions?
One more time, do I? Say that
You,
again?
you get to ask questions of, Ms. Dykes, Ronaldo Dykes. Do you have any questions for
Hi,
her?
Pam. I don't have any questions. Hi, Pam. How are you? I'm sorry that all this had to happen. I really, truly plan on resolving this. I know you've heard that before, but from my heart, you know me as a person. I really want to resolve this. I didn't want it to get this far, but as we've talked about in the past, I've had cash flow issues and I'm starting to get resolved a little bit by little bit. But you know, you have to do what you have to do. But I never received that letter from the first attorney. I swear, I never received anything. I don't recall any letter from the first attorney. The
That
second
letter was
attorney,
sent,
Mr. Heatherington, I did get that letter. What's that?
that letter was sent certified by Attorney Tony Mainprice. Your Honor, he bills thousands of dollars every month as a practicing doctor of podiatry medicine. I am unwilling to accept any further excuses as it has irreparably broken our personal and our professional relationship.
To be honest, it doesn't sound like you're missing out on much, except, $11,000.
And for my sake, then this loan was sometime in May of 2023, true?
I'm sorry, the judge speaking.
I'm sorry, 2023. The loan was somewhere around in May of 2023.
Yes, correct, so
So it's been,
a couple of years.
yeah, been 2 years, it looks like. Mr. Heatherington, I guess I don't have any further questions. I did ask for as far as what this was payments were for, you did, and it says she said just payroll.
That was her understanding when the loan was made. Your Honor. Correct.
When he was, yeah, but she also said that, ma'am, is what you stated, you said as far as you knew, the money was used to make payroll?
Yes, doctor and I were in clinic and he was on the phone and he got off the phone and said that he was unable to make payroll and could he take a short-term loan to pay his upcoming payroll. He has one person he employs as administrative person in his office.
So part of your complaint alleges that he was using money for personal gains somehow, but I don't hear that. And why don't you be upfront with me? Don't tell me anything else. If
I
that's
guess I
not
can't-
the case.
I
I'm
guess I
sorry.
can't be sure exactly what he's actually used it for. Since the time that the loan was given, he has continued to travel and he's bought a much larger home. So I guess I can't specifically know
Yeah,
what he's actually used the money for, Your Honor.
sure. Yeah, I'd rather just be upfront with me. So, okay. All right, Mr. Heatherington, anything else?
Sure, Your Honor. No further witnesses. I'll leave it at that.
Okay. Okay. I guess, Mr. Gold, you get a chance to call any witnesses you have, including yourself. You've already testified to a point, but if you have another witness, you can call that witness, or if there's something else you want to tell me with regard to your side of it, I'll let you do that.
The only thing I'd like to say is, like I posed to Mr. Heatherington yesterday, is I want to make resolution on this, and I really wanted to consult my attorney and get his okay, but since I can't seem to do that and we're at the witching moment now, I'm just letting you know that those are still my intentions. I still plan on doing just that. I don't want to hurt anybody, and I don't want to carry this on further than it is. I understand that it's gone on for a long, long time, and it's all my fault for that. But I do want to make good on it. I just know that if we get that penalty, that's going to be just a ginormous amount.
Yeah, it's a ginormous amount. And it would behoove you to inform your inner narcissist that while it is a ginormous amount today, it was also a ginormous amount when you fraudulently procured it from the plaintiff.
So I guess I understand all that, but let's stick with the trial, I guess, itself. Anything else you want to tell me regarding the contract or the agreement between you, anything else?
I don't recall the contract, so I don't really know that I can offer anything that would be of value
Okay.
for my side.
Okay. So I think what, Mr. Hetherington, you've closed your proofs as well.
Correct, Judge.
All right, let's sit here. It's 10 o'clock. I'm right in the middle of an, well, you know that too. I've got my other dockets in here too. Let me do this for, Mr. Etherington's not gonna like it. I'm gonna take a recess off of this matter until after I finish up my docket. We'll come back on and I'll make a decision for actually all three of you, okay? So let me just,
Can I make a brief closing?
sure.
Judge, I believe we've met our proofs as far as statutory conversion goes, maybe not
Yep.
necessarily the fraud concept. Obviously, the funds were used for some interest personal to Mr. Gold or Dr. Gold, whether it be to make payroll or to buy rims for his new car or whatever. He used those funds for some interest personal to himself, which is one of the requirements of conversion. And then at this point, through numerous requests, he has failed to repay any of those funds. So regardless of the manner in which he used the funds, whether it was for payroll or whatever, he's failed to live up to his obligations under the contract. That amounts to conversion. And under the statutory conversion, we are allowed to receive treble damages, which would increase the amount of the damages in this case to $33,000. We're also allowed to recover attorney fees. And I know in the default judgment, I put in 2,500, which was the original retainer. In this case, obviously we've gone above that, but we will leave it at 2,500 for the sake of today's purposes.
Well, that's an unfortunate twist. Due to the fraudulent nature of Dr. Dumbfuck, the plaintiff can and will be asking for 3 times the damages and attorney fees in the amounts of $33,000 and $2,500 respectively. And they can do this under MCL 600.2919A. Essentially, he just turned a $12,000 interest-free loan into a $36,500 loan, all because he didn't want to pay it back as promised.
But that wasn't my intention. I didn't defraud anybody.
Sir,
I didn't say I was using this and
Mr.
using it
Gold,
for that.
hold on. I haven't made any decision. He's giving me his argument for his side, okay? After all the
Yes,
proofs
sir.
are in, he's get a chance to do that. I was quite frankly gonna hold off till we came back on, but it's probably better now in case there's some discussions. From your side, I guess, Mr. Gold, you've got a final argument. Is there anything that you want to tell me as far as the argument with conversion? Why I shouldn't grant conversion? Or
Yes, sir, because it wasn't a loan to obtain funds to use them for purposes other than my living and my payroll. I wasn't using the funds to gamble, to go and invest in crypto, or to do something that would be completely absurd. I was using them to live and to make payroll. I mean, my payroll is for living. I wasn't doing anything extravagant. I was just trying to survive. So the fraud, I mean, it's not what happened at all. I committed zero fraud. I didn't do anything of the nature. I simply used the money for payroll, for expenses, and to live. It's all it was used for.
So you took out a business loan, but only used a portion of the money for business and the rest of it for personal expenses. In other words, you just admitted to committing fraud.
I made no representation, and I didn't do anything that would violate any kind of fraudulent activity. I did none of that. So I don't know that that's really correct. I don't know how the court would view that, but I did nothing fraudulent. I took out a loan and I just didn't pay it back, and now I'm intending to pay it back.
Okay.
I mean, yes, it's to the witching wire now, but you know, I want to get this resolved. Yes, I took too long to respond and reply, but kind of got a wake up call. Pay it back now. Do the right thing.
All right, so I've heard argument from both sides. I'll review my notes regarding testimony taken in the meantime and render a decision. If it just by chance, Mr. Gold, your attorney contacts Mr. Hetherington, or your attorney and yourself contact Mr. Hetherington in the meantime, you can certainly discuss it before I make a decision, but I will make a decision on the claim for conversion. And there's a claim for fraud too. You know, I'll consider both of them as far as what I've got as far as evidence. Okay, so we'll do it that way. Why don't we come back on and let's see. We got, let's say, how about we say 11:30? I might be being too positive about it, but 11:30 or so. Everybody come back on.
That's fine, Judge. Mike, does my client need to be here for that, or?
I'll leave it up to you, Mr. Hetherington. We've taken proofs and everything's in. You've made your arguments. You know, she doesn't have to be here, but no.
Very good, Judge. She has some other appointments, so I'll probably have her released up, but I'll be back on at 11:30.
Okay, Mr. Gold, same with you. You got to come back on though, but if there's any conversations, I suggest you talk to Mr. Hetherington in the meantime, okay? Before I make a decision. All right?
Okay, one more time on that, Judge.
I said,
repeat the last
if
part
you
again.
get a hold of if you get a hold of your attorney between now and the 11:30, make sure you contact Mr. Hetherington, your attorney or you or one of you, okay? But I'm going to make a decision when I come back on here.
Okay, Your Honor.
All right.
Yes,
All
sir.
right. And we'll leave it at that. Okay.
Thank you, Judge.
All right. You're welcome.
So they step away for a moment, and the doctor and the attorney come together on an agreement. However, the doctor already begins to show doubt that he'll even be able to pay off the loan as agreed before he even leaves the call.
And do we have Mr. Gold? Did he?
I'm
show
here, Your
up?
Honor.
Oh, there he is at the top.
Yes, I'm here. I almost called and I didn't know what happened to you. Last I heard was Peters and you were going to get some water.
Yeah. Yeah. That got hung up on some other matters in chambers. What, I guess have the two of you talked?
Your Honor, we have, if I may, I can put the terms of an agreement on the record.
Sure.
So Mr. Gold has agreed to pay a total amount of $15,650, which is the $11,000 that he owes currently, along with some attorney fees. That is going to be paid $2,000 starting this Friday.
Okay.
And then $1,000 each week until paid in full. He will also execute a pocket consent judgment for the $35,660 that we're seeking here, with credit for any payments that he makes prior to that if he should default. In return,
Time out, sir. I think we misunderstood what I said. When we were talking yesterday, I said 2,000 on Friday, 1,000 next week, and 1,000 a month till it's paid. 1,000 a week I cannot afford. That'll ruin me.
Then, Judge, I guess we don't have a deal, Judge.
Is that what the interpretation was?
Well, that's what my
1,000 a
client will
week?
agree to. So,
But I asked you, and you said you're going to bring that back to your client, and then you came back and said it's a goal.
I did, and when we spoke at 11:30, right before we logged back in here, that was the agreement that I put on the record with you. Well, that I talked to you about, and you said okay, so I was putting it on the record. But if you don't agree to that, then we'll just let the judge make his ruling.
Oh, sir, I can't. 1,000 a week? God, no, I mean, that'll just put me in default. I mean, it'd save the courts time and just say I'm going to go into default right now. I mean, I want to pay, but I when we spoke yesterday, I said 1,000 a month until it's paid off. So 3,000 like between now and next Friday, and then 1,000 a month, and then we're done. I mean, I know that he might have heard or thought of it. I meant 1,000 a week, but 1,000 a month will pay off. It's 8 months. And
Mr. Gold, Mr. Gold, it's either there's an agreement or there's no agreement. And quite frankly, I guess it's your decision. You know, if you want me to follow through with my decision, I'll go ahead and do it right now. But I can see what's happening. This is being dragged on every time you turn around. being stretched further. So if you got an agreement, fine. If you don't, I'll just make a decision here.
Can can we stretch it a little bit? 1,000 a week is gonna cripple me.
Are you really complaining about having to pay $1,000 a week when you originally asked her to pay $12,000 at one time? And let's not forget, you always have another option. You can just take the $35,000 judgment against you and deal with the credit collectors coming after you.
I mean, I know that I'm past the prime now, but can we at least make it so I can breathe? That'll suffocate me. I mean, I'm willing to do the 2,000 Friday and 1,000 next week, and then go from there. But 1,000 a week? Can we go longer? A little longer?
That's not what my client agreed to, Judge, so I'd ask you to make your ruling.
Okay.
I mean, I'll send the $2,000 Friday, no problem, and 1,000 next week, no problem. No problem at all. I mean, I want to get this done, but
I'm not, sir, you're wasting a lot of, quite frankly, my time now, and I've got another trial I'm getting ready to start. I thought this was going to be a simple one. Apparently not.
so did I. I thought that we agreed to 1,000 a month, but
Yeah.
okay, 1,000 a week. I'll send the money and 1,000 a week. I'll get this done.
Okay.
If he's agreeing to that,
Can we
Judge,
listen on the court cost?
With that,
if he's agreeing to that, Judge, I can prepare a settlement agreement for his signature. Of course, my clients and myself. I'll do a conditional dismissal with a opportunity to reopen if he should default with a pocket consent judgment. Again, that'll be for the amount that we asked for in the default, which is $35,660 minus any credit for payments that he does actually make before he defaults. And in order to enter that pocket consent judgment, we must file an affidavit of default with the court, which we would be willing to do. If he satisfies the settlement agreement, then we will enter a order with prejudice dismissing the case.
okay. All right. We'll do it that way then and expect the consent judgment, I guess, with the conditional dismissals, really what it is. But
Very good, Judge. I'll get that drafted up today and over to Dr. Gold.
all right. All right. Good luck to both sides.
Thank you, Judge.
All right. You're welcome.
Thanks.
All right, so it looks like they eventually came to an agreement and he promised to pay back the loan at $1,000 per week, which as a practicing podiatrist, he should be able to do by shaving off a few extra bunions every day. And I did some research on this guy to see if this was just an isolated event. And of course, it's not, as I found this Google review which alleges that he borrowed $8,500 from one of his patients, which he didn't pay back as well. So if you liked the video, hit the like button. If you disliked it, hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm Team Skeptic, and I'm out.